I'm going to call the listening session to order. So I just want to kind of go over like why we're here and kind of what we're planning for tonight, and then we'll proceed. So this is the court's effort to receive feedback from the public on the juvenile court system, the possibility potentially of us transferring jurisdiction to the circuit court for our juvenile delinquency and dependency cases. And so kind of how I'm thinking the night is going to go is we're going to start with Amy Nation, who is our juvenile director. Just for those in the room who may not deal with the juvenile day-to-day, she's just going to kind of give us a juvenile court 101 that walks through dependency and delinquency. There's a lot of faces in here, folks who deal with the system day-to-day, so just please bear with us so that the folks who are kind of new to this can get some grounding, and we're using the same language so we're all on the same page. And then we actually have the circuit court with us today, and so we're going to ask them to come up, and I think the commissioners have some questions and they will be here as well. And then we will open up the floor to the public to have comments. Depending on how many of you, Sandy has a clipboard that's going around, so depending on how many of you there are, we'll probably try to limit those to maybe 5 minutes if we can, just to make sure everybody has an opportunity to speak. But that's kind of how I'm anticipating the night will go. So with that, I will turn it over to Amy to just kind of give us a Juvenile Court 101 overview, and then we'll dive right in.
Thank you all for coming. I appreciate it. I guess I need to advance the slides as I go. So in the juvenile department, we have two different types of cases. We have delinquency and dependency cases. So a delinquency case is a violation of a law prior to a youth turning 18, which would have been a crime if it had been committed by an adult. And on our dependency cases, it's a dependency case is to ensure the safety and well-being of a child who DHS determines is at a significant risk of becoming abused or neglected. In these cases, no violation has been committed by the youth. However, it doesn't always mean that sometimes the dependency case isn't also a delinquency case, because they can cross over. So what happens when I get a delinquency case is a youth commits a crime where they have a violation, and I'm given a police report from local law enforcement. After I review the police report, myself and the district attorney determine our next course of action. Then when we decide kind of where we want to go with this crime or violation, I meet with the family, I do an intake with the family, and then I talk to them about what's going to happen next for them and for their child. So I can go two different ways. The district attorney and I kind of decide how we want to proceed when we have whatever the offense was. For many first-time offenses, particularly if they're less serious, so maybe just a violation like MIP of tobacco or something like that, I will offer a formal accountability agreement. And so what this is an agreement between the youth and myself that if the youth completes successfully means that they don't ever even have to go in front of the judge. In those types of cases, the youth and the family is still entitled to an attorney to go over the agreement. They still are put on conditions of probation. They still have things that they need to do and follow to be held accountable, but they don't have to go in front of a judge. And then if they don't follow that agreement, then I can revoke that agreement, and then we go into the court process. Or for serious offenses, this might be where we start, or second offenses, reoccurring offenses. And in that case, I file a petition with the court. The youth does go in front of a judge. And if I have to detain the youth, then I have to have an emergency hearing by statute, by law, within 36 hours. So after we have our court hearing, I meet with the youth and the family again. I want to make sure that they've understood what happened at the hearing. It's usually pretty stressful. And so I just want to sit down with them in a calmer environment, talk with them, make sure they understand what happened, give them a copy of any conditions of probation that the judge may have ordered. And I also give them my contact information. A lot of times questions come up for the family after they get home, and I let them know they can call me whenever, evenings, weekends, whenever they need if they have questions. And if I can't answer the phone, I'll call them back as soon as I can. And then when we have a youth who's on probation, I meet with them weekly. I do this just to check in with youth, make sure they're compliant with, I put case plan there, but really their conditions of probation. I help them with any needs they might have or their family might have. I work with the youth on anything he or she may need help with to ensure a successful probation period. Usually I'm helping them with things like setting up tutoring if they need it, making sure they're going to counseling, making sure they're following their curfew. It's just really a check-in. Sometimes we have some courses they can do online that deal with maybe addiction or things like that. And I might be making sure that they're following through with all of those things. So in a dependency case, these are DHS cases. The first step is we have a shelter care hearing, and this must be held within 24 business hours upon DHS removing a child from their home. So DHS will call me, tell me they need shelter care within 24 hours, and we do our best. Well, we do it. We scramble to get it set up. And then after we have the shelter care, we have what's called an admit-deny hearing. And this needs to be held within 30 days after the petition is filed. So the petition is filed at the shelter care hearing. Within 30 days, we have to go to the admit-deny. And this is where parents, they have attorneys by this point, and they either get to admit or deny the allegations in the petition. So the allegations are the reasons DHS removed the child. So they'll list whatever they felt the concerns were in the home, and this is the chance for the parents to admit or deny what those allegations are. If parents deny, then we set a trial date, and we try to come to a resolution before that trial date so we don't have to go to trial. It doesn't always happen, but often it does. Attorneys, parents, and DHS all work together to try to come up with some resolution. And then within 60 days after that petition being filed, we have to have what's called jurisdiction and disposition. And a jurisdiction hearing is all parties have agreed to these allegations, and a judge finds that the court and DHS have jurisdiction over the family. And then usually at that same hearing we go into disposition, which is when the court orders the family to participate in certain services or meet specific conditions in order to get their child back. So it just kind of lets the family know what they need to be working towards and able to be reunified with their child. And then after we have established that, the family is usually in front of the judge about every 3 months. They're called review hearings. It's just a chance for the judge to be updated on progress or lack of progress on the family and a check-in. And we can schedule those more often if needed. If there's a concern that comes up before those 3 months or somebody who's a party to the case wants a hearing, we can certainly do it before those 3 months. But we try to do them every 3 months minimum. And then by statute, by law, we have to have what's called a permanency hearing 12 months after jurisdiction is established, or within 14 months of when a child is placed in substitute care, whichever is sooner. It's very similar to a review hearing. There's certain findings and things that have to be in the court order, but it's kind of the same idea. And the review hearings and our permanency hearings continue as long as the dependency case is opened. Do you want to go over the public concerns?
Sure.
Okay. So some of the public concerns we've been hearing about since this conversation has started is one is difficulty or delay in scheduling our hearings. So in mid-January, we transferred all of the current juvenile cases that we had open to Judge Wolf. And during this transition, because the cases that we currently had opened already had some scheduled hearings set from our previous judge, Judge Schaefer. When he was here, we had some review hearings set. So for those that we had set, one was delayed by 24 hours, and all the other hearings were held on or before the hearing date set by Judge Schaefer. And regarding scheduling new cases, because we had several new cases come in right after the new judge came on, and we transferred those to circuit court as well. So we had those emergency hearings that had to be held within 24 hours. And the circuit court has, without fail, made judges available in person or via video conference within the statutorily required 24-hour period. Another concern we've heard is loss of personal connection between the judge and the kids and the families. And while it's true that our circuit court judge does not have personal connection with the parties in our cases, they have been very patient and generous with their time. I've sat in front of 3 of our 4 circuit court judges. They've explained the legal process options to the children and their families. They've explained the differences. You know, if you admit this is what you're admitting, this is what happens, you have the right to deny. They've been very patient with our families and our kids and explaining the process to them and answering questions and listening. And the lack of personal connection has also ensured the impartiality of the judge hearing the case. Another concern has been that the circuit court judges often participate in hearings via video conference, which lessens the gravity of the situation for the youth and the parents. Our experience so far has been that the circuit court judges have made every effort to schedule in-person hearings. They have had to conduct some hearings through video. In many cases, the ones they've had to be by video for have been those emergency 24-hour hearings that were unexpected. And of our 3 emergency hearings held since January, we did have 1 done in person, 2 were conducted by video. But with all 3 of those emergency hearings, Judge Farrar was out of the building on county business anyway, and she also would not have been here in person. She would have also had to appear by phone. And some additional things to think about are our circuit court judges have law degrees, training, and experience to handle these cases. The court orders are prepared by the circuit court judge rather than by the juvenile director, which ensures that they are legally sound and frees up the juvenile director to spend more time with the children and families involved in our cases. The county judge is able to supervise and support the juvenile director without creating inappropriate ex parte contact. For those of you who might not know, ex parte is I'm not supposed to be talking to the judge about the cases outside of the courtroom. They're supposed to be completely neutral, just getting what they get in a court report or hearing in the courtroom. So there's not supposed to be any talk outside of that. And going into circuit court covers the costs of attorneys and translator fees for cases under their jurisdiction. In addition to these costs, the Gilliam County Juvenile Department currently pays for conference calls when we need to set up multiple parties on the phone, and currently pays for training for the county judge. And so transferring the jurisdiction of these cases to the circuit court would save Gilliam County taxpayers about $33,000 per year. I do have a copy of the PowerPoint if anyone wants it, and if you have questions for me, I'm happy to answer them.
Commissioners, any questions?
Very well done, thank you.
Huh?
It's very well done, thank you.
Thank you.
Okay. If you want to stick around in case.
Oh, yeah, I will stick around. Absolutely.
Goodbye. Good, you're done. Bye. See you later.
No.
I'm wondering maybe if the circuit court might want to come up and say hello. If you guys, we met Judge Wolf in Arlington. But this is a new face, so.
You want us to sit here?
Wherever you like, that's fine.
I'm Janet Stoffer, and I'm the presiding judge for our district. So for Hood River, Wasco, Sherman, Wheeler, and Gilliam counties, my office is primarily in Wasco County. And as you know, we come out here fairly often to see Mr. Weatherford occasionally. There's 4 judges in our district, and we're all circuit court judges. We all move around. So that's, you know, it makes it possible for us to try to get to all these hearings between, usually one of us can make it. Judge Wolf tends to be the most free with his time, so he's likely the one that we're going to send out here if we can. but we're all available to it. And this is Angie Tennyson. She is the trial court administrator, so she administrates everything. She makes sure that some judge is going to get out to wherever we need to be, and the paperwork is properly filed.
And also, many of you are probably familiar with Mary Beth Jagger.
Thank you.
So I don't know, commissioners, if you had questions. There were some things that we had asked Judge Wolf, but I think it might be beneficial to have for this audience to hear, as well as some of the things that we talked about in Arlington. So.
I grilled it pretty good, I felt like.
You did.
Okay, I might as well just start off with a bad one. One of the things that I've heard from constituents in my neck of the woods is that, you know, we've gone into some agreements with not only just Wasco County, but other counties, and you know, it starts off really strong and everything's good, and then it kind of wanes over time. And so I guess that was one of the questions I asked him, just looking for a little reassurance that if we do go this route, that the service will continue to.
Well, it's not an agreement with Wasco County, first of all. I campaigned out here. In fact, I knocked on a few doors when I campaigned out here a few years ago, 10 years ago. So this is my district also. This is my courthouse also, as with the other 3 judges. So, and it's not really an agreement. It's by statute that you guys have in juvenile stuff. It's your decision. You can keep it, and we're happy that it goes that way. But if by statute you decide you want to transfer it, we get it. And we have to take it if you transfer it. So we're not here to weigh in on whether you give it to us or whether you keep it, because by statute, if you want to give it to us, we have to take it. So, and I think that presentation that Amy did was really good. It exactly set out, you know, what some of the issues are with keeping it local or not keeping it local. And you're right, my office is an hour and a half away. So if I can't get here, then you see me on the video. And shelter hearings totally take precedence. In fact, I had a shelter hearing today at 2 o'clock. And I thought, I have to get through this hearing because I cannot not show up for that meeting out in Wheeler County, or in Gilliam County. So, yeah. So they are priority. They take priority over almost every other thing on any of our dockets. And as judges, we've committed to come out here, not just for the juvenile stuff, but for the criminal stuff or for anything that we have. We try to be a body in person out here. And frankly, sometimes we fight for it. It's a nice day, the day I have to go out to Gilliam and Wheeler County. It's a different world than being stuck in Dallas. It wasn't a nice day, like about February 10th. But normally, we love coming out here. It's a different environment, and it's a good one.
That's good to hear. Then when I talked to the previous judge, you know, I felt a lot better after just visiting with him a little bit about, you know, that how it works. The other thing that I've heard people say is that, you know, just concerned about the workload that you guys already have. Mm-hmm. But it sounds like you just have to fit us in.
We will fit you in. There's no doubt about it. And we have kind of a unique situation with Judge Wolf and I. Judge Wolf can't do a lot of the cases in our courthouse because his wife is one of the DAs. So he has more free time than the rest of the judges and availability to go wherever we need to send him. We send him to Hood River a lot, surprisingly, you know, to cover conflicts and stuff. So we kind of have that extra body that we can move around more easily.
Well, and I would add, I believe that we currently have all of your open cases that have, at the moment, been transferred as you evaluate what decision we want to make going forward. And I think we've been able to handle that workload comfortably between the judges and staff, because staff is the other side of it too. But I think we've been able to manage that with no problem.
Another question that came up was how many counties still have the setup that we have of having a local judge handle these cases. And I guess there's 3, and it's just...
Yeah, I believe currently, I believe that Gilliam, Wheeler, and Sherman counties are the last 3 counties in the state that have maintained county jurisdiction. I believe the other counties that were allowed to have jurisdiction by statute have subsequently, you know, over the past 20 or 30 years, transferred that jurisdiction to the circuit court.
And is it true they don't get it back? if they changed their mind and they wanted it back. That was a concern that I had.
The statute may read that way. It may read that way, that once it's transferred, then
That's my
I think
it
that's an important
advances, yeah.
piece.
And I believe that Gilliam County, we would advise that they would talk to county council about
Oh,
that.
we met with legal counsel.
Yeah, we did discuss it with legal counsel, and that was his interpretation, yes, is that when the legislature passed it, they had sort of intended that really the jurisdiction is the circuit courts except for these counties, and when these counties make the decision that they no longer want that jurisdiction, then it defaults to the circuit court, and that's that's not something you can reverse once you do it.
There's something else. Another thing that was brought up at a previous meeting was that that if it was to go to the circuit court, that we try to keep delinquency cases and dependency cases with the same judge.
Oh, one judge, one family?
Yes.
So
Thank you.
Johnny has a delinquency case and a dependency case?
Yes.
Yes. If they've got a divorce case, if they have a criminal case, that is our goal, is to try to keep one family, one judge is what we say. So it doesn't always work that way, and sometimes a conflict will end up because I learned something in a delinquency case about a parent who's charged with a crime or something, so there might end up some conflicts, but our normal process in all of our court cases is to keep one judge, one family.
And whenever possible, we try to keep the case with the judge who hears the shelter hearing, and we try to keep that case for the life of the dependency case with that same judge, so they keep current with all the facts and know the history. And also the families are more familiar with the same judge.
What would you say to someone that the other thing I hear too a lot up in Arlington is just losing the local control, that and that you don't want to give it up once you give it up it's gone. But what would you say to because I've also heard that the juvenile director is still very involved, even if the judge is a circuit court judge versus a county judge.
Juvenile department is always involved in all of my juvenile cases. They're at the table, they're providing reports, they're letting me know how the delinquent child is doing or how the foster child is doing, as well as DHS, CASAs. We have big tables at these hearings. As far as local control, again, it's your guys' choice. It's your choice. I think one of the advantages Amy pointed out is that as judges, we try to stay really neutral. And it might be more difficult. For example, I live in Duford. I probably know just about everything about every family in Duford. And I might not be the best judge to hear Johnny's case because I coached him in baseball and his mom's in my book group, whatever. So sometimes it might be a benefit to have a judge that's totally neutral in a court situation.
And I would also add that things like the formal accountability agreements, all of that process still remain local. That process doesn't change. So whether it's a DHS case that doesn't go to a removal from the home, just open cases where children remain in the home with their families, that's all still the same local players and stakeholders. The decisions, the families that have juveniles that are on a formal accountability agreement, all of that process doesn't change at all. So that decision-making about whether that's going to be a formal accountability agreement in the case of a delinquency case or whether it goes to court is still all locally determined. And so it just functionally, to some degree, just changes which court it gets filed into. And so it's my understanding that the juvenile department's role is actually similar in the juvenile department's role, whether that case is in county court or in circuit court. So in terms of those dynamics, I think there's quite a bit of similarity in that, in your role.
All the recommendations are still coming locally. If it's a delinquency case, all the recommendations that a circuit court judge is seeing are from me getting to know the families and working with the families. And the same thing with DHS, when they're seeing all of that, it's coming from our local DHS. So that's where your local control is still in place.
CASA, yeah.
Oh, and CASAs, sorry. Yep, and CASAs as well.
Other questions?
I just really want to hear whatever,
Yeah.
what everybody has to say about it.
I will say, though, I really appreciate, because this is now twice that we've seen 2 circuit court judges make the trip just to participate in this discussion, so I appreciate that.
Thank you very much.
All right, well, with that, I guess what we will do, you guys can sit and
If you
want to go out
answer questions?
there, or it's up to you. Does anybody in the crowd have any questions for the circuit court? while they're here. Anybody? Les?
Can't go without a question.
You want to introduce yourself so you're on the
Yeah,
record?
Leslie Rock, Rock Creek. And Judge, I guess to the presiding judge or whomever, I've been interested from the onset of this in terms of whether there might be a reversal of it or the court to decide to go forth with it. And tonight's the first indication that I've heard that there is a statutory lock-in, so to speak. Once you're in, you're in. And I'm wondering that's true to a certain, if that might not be true to a certain extent. So my question is, if the court were to decide to go forth with this proposal and the circuit court ends up providing the services and for some reason or reasons the local community becomes dissatisfied with how that's working out, cannot we end up at the Oregon legislature to amend the statute, or might?
I think you could.
I guess it might be more aggressive.
I think
Couldn't we also be looking at that right now? As a part of making the decision to go forward with this?
We could certainly talk to
I mean, we
legal
could
counsel
certainly,
about that.
we could
but-
certainly pursue it but I don't know this late in the session, whether that would even be something,
Not this session.
yeah.
During the interim and into the next session, it certainly could be.
Yeah.
But the point I'm making is, and I guess I'll take this up too, just to put on record a little bit of comment here, and that is that I think it's worth a try. And I say that with having had reluctance and some reservation of doing it. But I think we need to go forth with it. And as a part of that, I would recommend that the county court consider looking at putting two things in place along with it. One, some sort of a local committee that might have an opportunity to have an impact on working with the judges to make sure it works. And two, looking at a proposed amendment that would change the statute so that the similar counties could take it back, so to speak, if they chose to. Thank you.
You know, in some of the counties, well, actually, I think only in Wasco County, not in Hood River, we have the Juvenile Court Improvement Project, which we meet quarterly with the community partners, with people from DHS, with CASA, with the DAs, with the defense attorneys, to talk about issues in the juvenile court. We can't talk about a particular kid or a particular family, but we can talk about, you know, these 2 o'clock hearings just aren't working for us. We got to do at 4. Or the state isn't providing the discovery that we're supposed to get a week ahead of time. Nobody ever gives it to us. So we talk about issues that happen in the juvenile court and try to come to a consensus about how the juvenile court should be running. So they could certainly set up a JSA out here. Yeah. Yeah.
I think, if I may, Judge, I think one of the issues that you're going to run into that you're going to have to look at in those terms is the video conferencing involved. I think that's a pretty important element going forward here, and it needs to be much more successful, I think, than it has been in some circumstances in the past.
And I will say, I mean, maybe Amy can speak to this too. I think, and she said it in her presentation, I think where the video conference has been needed has been in emergency hearings in particular, where we have short notice. What I've been witnessing since then, though, is once the judge has that case on their docket, they usually are sitting up there scheduling with the attorneys and saying, okay, I can be here this day. Can you attorneys be here this day? And so that really we're not, now that we've got those cases sort of working through the system, we see circuit court judges in this building way more often than we've ever seen them before. So I mean, maybe Amy has a different perspective on that, but I certainly know that this room is blocked a lot more often than it usually is, and usually there's a circuit court. It's because there's a circuit court judge in the building.
I have noticed their effort. You know, they know we're going to have a review in 3 months. They look at their calendar at, you know, the shelter care, or if, you know, it's for the inmate to die in 30 days. They're looking at that hearing we're in, looking forward on when they can be here. We have circuit court judges scheduled here just from the adult court, 2 Fridays a month. But I will say that scheduling going forward, I'm seeing Judge Wolf scheduling a Tuesday. He has a free Tuesday, and so he can be here. I'm seeing, same thing. I haven't got to sit in front of Judge Stoffer yet, but Judge Austri and Judge Olson, same thing. If they have a Tuesday, Wednesday free, and that's what works for attorneys and that's what works for them, they're scheduling to accommodate, and they're just making a special trip out here for our cases. We did have one case that, it was a review hearing, and no parties are going to be in the courtroom, and I just let Mary Beth know if the judge doesn't want to come, because in that case, the judge would be sitting here staring at an empty courtroom anyway. It was a delinquency case. The delinquent was in a facility somewhere else. The family does not live in Condon. They were going to appear by phone anyway. So in circumstances like that, I just let the judge know, really, you don't need to make a trip out here for an empty courtroom. But when they know people are going to be here, I'm seeing them make effort to be here in person.
And I would maybe add on to that and kind of on to one of the questions, that is this just an initial effort because everybody's concerned about it? I would say no. The reason that hasn't happened historically is because those cases weren't in circuit court. So this isn't a transitional demonstration. This is because we now have these cases. We didn't have them before. So it's a reflection of having those cases in circuit court now. And then I didn't know if we want to give an example. The other thing with shelters, in terms of talking about emergency hearings, I'm not sure if people understand the timeline. So for the shelter that Judge Hoffer heard today, we had that filing at a little before 11.
We didn't have the filing. We got a call at 10:23 that we had a shelter hearing, and I had to find sometime between 10:23 and I had a hearing starting at 10:30 and 3:30 when I had to leave for here to get it in. So, and we try to do our shelter hearings always at the same time at 2 o'clock, so I just scheduled them in at 2. And luckily, it didn't take too long.
But because of statutory timelines,
Right, so
that's
they
an
picked
example
up
of why
kids
we have to
yesterday,
be-
and we get a call from DHS that says we need a hearing within 24 hours. That's the biggest one that's difficult. Any other hearing, I can look at my calendar and I can put it on the calendar. But those are the ones, especially if we've got one judge on vacation and 3 judges in the middle of a jury trial, we've got to set everything else aside to get that hearing in.
And another example of that is the one, Judge Austri, that was our shelter hearing when she was in person. It happened to be a Friday. She was here anyway for adult cases. That juvenile case took precedence and was heard before the adult cases. So.
Any other questions?
Well, and it's open court too. I'm sure your court is too. So if somebody's concerned about a juvenile matter, come on in. Everybody's welcome to come in. Yeah.
Go ahead.
Jan Moffett. I was the juvenile director for 10 years in Wheeler County and 10 years in Gilliam County, and I don't understand why this is coming up now. I guess what worked. It was our community, our kids, and we took care of them, and everything seemed to be working okay. We had more kids then than we have now. So I guess I just need to understand why. Why do you want to move things out of the local jurisdiction?
I mean, I can speak for me. I don't know that the commissioners have made up their minds, but I think I was pretty clear on it when I ran for judge. I believe pretty firmly that a person with a law degree should be making these kinds of decisions. It just comes down to that. When you're talking about custody of children and deciding legal decisions, I believe, if you sit in those dependency cases, you've sat in them. You've got DHS, the Assistant Attorney General is coming. Mom and dad both have attorneys. All of the kids that are involved have attorneys. The only person who doesn't have a law degree is the judge. And I look at it, from the county perspective, we don't even pass a contract here without having an attorney look at it. And yet we're allowing somebody that has no legal training to make decisions about who has custody of children in our county. And my vantage point, that person should have a law degree. They should be legally trained. It's appropriate.
So as a follow-up to that, what kind of training would you be provided with if you were to do the training session?
The training for the county judges is 2 weeks in Reno, and that's it. There's no, to run for my position, there's no requirement that I have any education of any sort. So that's the extent of it. It's 2 weeks. Personally, my vantage point is somebody who went through law school, passed the bar, spent years as an attorney, and then was elected to a judge is probably more qualified to make those calls than somebody who spent 2 weeks in Reno.
But what about, I'd like to hear the district attorney's, what he has to say, because it seemed like that was always the one I worked with, was the district attorneys.
Well, I'm the one that didn't sign the sheet that.
By the way, so this is a good segue, because I think we had some people come in after we passed this around, so we'll get back and make sure that we get to everybody that's on there, but this is fine if we want to do kind of a freewheeling, that works for me too, but.
But I know there are people on there who really have some strong feelings, so we want to make sure we get to them for sure.
For sure, yes.
I have 2 questions. Actually, I have 3. If the juvenile director writes the court orders, who reviews the legality of those? I have concerns that you might be liable for
The judge reviews them and signs them.
the judge, that if they've had 2 weeks.
That would be,
or-
that's my 2 weeks,
Okay.
yeah.
So, the other thing too is, if you can keep the ability to, if Judge Farrar can keep the ability to sign the cases over to circuit court, is that a possibility? You know, so at least there's, the judge has the eye on what's going up, and then do you understand what I'm saying?
No.
So right now, she signs the cases over to circuit court, right? Because she's the judge.
Yeah.
She signs an order to send them up to the circuit court. So if she continued that function, could you continue that function? Or is the only way that the state's gonna pick up all the costs is if we turn it all over?
That makes
Did
sense.
you guys ask legal counsel that question?
We have.
We did not.
We did not ask
that one yet.
I did ask that at one of the discussions we had. Can we just continue doing it this way indefinitely? And they said yes, but I don't know about the money.
See, that's the thing, is if we're saving $33,000 a year and they're all going up anyway, then it would make sense to make the formal move. But if there's a way to do it where then at least Judge Farrar and Amy can still know that it's going through the process and they're not missing any steps, at least for the first year, to make sure that you're comfortable with the way it's going, I was wondering if that could possibly be
I
it.
think you need to have somebody look closely at the section and make that evaluation.
But if it was just signing them over, I am for also too is having an attorney in that position. But my last question is that if your 4 circuit court judges, say 2 are on vacation and 2 are tied up in jury trials, and I know the juvenile case would take precedence, can you call in another judge
Yep.
from a different region?
Yep, we can get a judge. We've got Plan B judge, so retired judges that we can call in. And we also often do trades with Jefferson County or Deschutes County.
So there's never really a lack.
Sometimes every judge in our district will have a conflict on a case.
So I guess I have 4 questions. Has there ever
Yeah.
been a time where you've missed the deadline?
So yes, the OJD the Oregon Judicial District will get us another judge within that time frame.
So that is you will never miss a deadline because you always have judges in reserve if yours are unavailable.
Since I've been here, we've not had an issue with that.
Thank you.
Okay, so, do you have questions for the circuit court or for just
Well, I just want
generally?
to make a comment, because my sister was the CASA director at Union County, and the judge there depended very heavily on the CASA board to give them the recommendations for what their decision was going to be. It's not like they have to create the wheel here. They have people that are inputting into the information pool that makes the decision easy.
That's right. CASA,
So,
Juvenile Director,
Yes.
DHS, they're all.
yes, it's not like you need a law degree when you have all these people that are,
Well, CASAs aren't legal either. I mean, they're
no,
not legally.
but they know
trained.
what's in the best interest of the child at the point that they're working with them.
That's true.
Any other questions for circuit court before we start going down our list? Because I want to make sure we get to everybody that's signed up. Specific questions for them, and then if you have general comments or feedback, we'll. Any other questions for circuit court? Okay. Thank you. Yeah, you guys don't mind. Thanks so much. Okay, let's start and we'll go through. If anybody didn't have a chance to sign this, and I'm going to go through the list, and if there's some add-ons after, we'll bring those up too. So Jan, do you have comments beyond what you already said, or do you?
I guess it's like 10 years of building a house, and I see it kind of being dismantled, and I guess I'm just upset, because I think it takes the whole community to raise a child, and I think we can do it here. But what I'm hearing you say, you can cover it, but I've worked for district attorney's office, and you pretty quick, you have everybody's got to have an attorney, and this and that, and you got to do all the scheduling. Just because the circuit court judge is available doesn't mean the attorneys are going to be available, and I just see delays and delays. And I don't think that's in the best interest of the child.
I'm not sure though, just to clarify though, when those same things happen under the county judge, if it's the attorneys that are holding it up, I mean, I don't know that I have any more ability to compel attorneys to show up than a circuit court judge would.
No, conflicts have happened to both. I mean,
It seems,
Scheduling
from
is
what I've seen is it's really usually not the judge that has the conflict, it's getting all
yeah,
the attorneys
scheduling's a
in the
nightmare
room.
whether you're in
It's
county
usually
court
the
or circuit
schedule.
court.
Is usually the problem.
Mhm.
But I think I think it's worth having on the record. Any other that you wanted to add, Jan?
No, I'll listen.
Okay. Les, did you have more than you wanted to add, or did you say what you wanted to say?
I think I pretty much covered what I needed to say. I definitely support making the move, and I'd like to make sure that we make an effort to provide for making it work.
Okay. Catherine,
I'm fine.
you're good? You said your piece?
I had my say.
Judge Shaw.
Can I come up there?
Of course. Yeah, come on up.
I prepared a long letter, and I have copies for everybody.
Okay. Pass them down. Give one to Sandy, one to Mary. One to you. Oh, we got an extra. Maybe one to Mac if he needs it.
I thought I prepared them.
Help you.
Yep, you did. We've got an extra.
I'm going to read this because this issue is so important to me that I don't want to miss anything. So I'm prepared to read. I'm speaking to you because I feel so passionate about the issue that I feel compelled to speak. I really would rather be any place but here tonight. My experience in this issue includes 57 years as a parent and grandparent of Gilliam County youth, some of whom have had dealings with our juvenile court. Not because they were bad kids, but because they were youth with underdeveloped brains who sometimes acted inappropriately. I also have more than 26 years experience as a Gilliam County employee, 22 years as an elected official, and 6 years serving as Gilliam County judge. I only mention this to signify that I have the experience and knowledge to be well aware of all the pros and cons of the issue you have before you. I am also speaking not only from my experience, but also that of the colleagues I met while serving as this county's juvenile judge. The decision this court is about to make is one of the most important decisions, I believe, that you will make in your tenure as county commissioners and judge. When I filed for the office of county judge, I knew that the title of judge was affixed to the position because the duties included being juvenile judge and probate and judge of the probate departments. I accepted and look forward to serving in this capacity. Had I not been interested in serving in these duties, I would have filed for the position of county commissioner instead of judge. I have always stated and truly believe that our youth are the most important resources we have in this county. The three of you, myself, and many citizens of our county are products of this resource, as we were raised in this county. Working with the juvenile department, you will hear over and over, as we have tonight already, the term, in the best interest of the child. In my opinion, the best interest for our community's children is for their juvenile department cases to be heard by a judge located in the county and served by the people who know, love, and support each one of them and their families. What happens to these kids and their families not only affects them directly, but it also affects everyone in our communities. The goal of the juvenile department is not punishment, but rather rehabilitation. Being juvenile judge requires a lot of common sense and a desire to act in the best interest of the child. Similar to the Justice Court, who is also not a legal attorney, the judge in this position does not require a law degree. In matters of the law, you have the support and expertise of all the attorneys involved in each case, along with the support from the circuit court judges and our own district attorney. When I was juvenile judge during the court hearings, the attorneys were always my best resource in matters pertaining to the law. When I had difficult cases, Marion Weatherford, our district attorney, would prepare me as to the legal process to be followed. And the attorneys were super in helping me all the way along. If I erred in legal matters during the hearings, the attorneys would always gently correct me. As part of my training, and the training was the 2 weeks in Reno, but I also took a week for the National Juvenile Judge Conference, which was held all over the United States, and it was not that expensive, and it was very, very informative. So I did that every year. It was a refresher course every year. I was welcome to visit the courtroom of the circuit court juvenile judges, and I took advantage of every training opportunity. And the cost of my training was minimal, not the $30,000 I have heard mentioned. During my tenure as judge, we only remanded one case to circuit court, which we did under the unanimous advice of all the professionals involved in the case. On all the rest of the cases, I had total support from all the same professionals and attorneys. Traveling while on county business never interfered with juvenile cases. And I always put juvenile cases ahead of anything else. I don't think I ever had a conflict that I was the person that held up the juvenile department from scheduling something. I simply held a phone hearing wherever I was. Serving as judge of the juvenile department was the most rewarding part of my 6 years as county judge. In case after case, I could see the benefit of hearing these cases locally. There are 2 cases in particular that I can never forget, one in Arlington, one in Condon. One was a dependency case involving the whole family, and one was a delinquency case involving only the youth. In the dependency case, the family had moved to Gilliam County from California, and they'd been homeless most of their existence as a family. And they came into the juvenile court due to the actions of the parents. After several months of working with the family, we helped the father to find a job locally and to change their way of living, of course. And during one of the court hearings, the father stood up and thanked everyone involved in the case, including myself, for our part in changing the direction his family was going. He told us he was so grateful that his family ended up in our juvenile court and for the assistance we provided. I will never forget that moment. The other case was a young man who I watched grow up at the same time as one of my grandchildren. I was never impressed with his attitude. And this goes to the fact of knowing the families and how you feel about them and how you can be impartial. He had quit high school early and partly because the school was difficult for him, and partly because he lacked the family support to keep him in school. After some time of being out of school, and while he was still of juvenile age, he got into legal trouble and ended up as a delinquent case in our juvenile department. He told us how difficult his life had become by not being able to find decent employment, mainly due to the fact that he had never graduated from high school. We were able to hire a tutor, and he worked really very, very hard, and eventually received his GED. He was so excited because he had accomplished success that he made an appointment to come see me just to let me know that he had passed all his tests and received his GED. His excitement touched my heart and brought tears to my eyes. And after all these years, it still does. It was such an awesome moment and speaks to the fact that given the right circumstance and support, everyone can succeed. Neither of these cases, in my opinion, would have turned out this way if they had been referred to circuit court. Both were life-changing for the individuals. If we change the life of one youth or one family by retaining control of our juvenile judgeship, it is well worth the effort. I stated in the beginning that this is one of the most important decisions you will make. This is important because if you turn the jurisdiction of the juvenile department over to circuit court, you will never get it back. It is a permanent decision, now anyway. This not only affects our lifetime, but that of every generation to come. All of the former Gilliam County judges adamantly are opposed to releasing control of juvenile judgeship. Years ago, one of my peers from another county told us that the worst decision they ever made was to turn their juvenile judgeship over to circuit court. Please listen to those people who have experience and knowledge and have previously walked in your shoes. Our county, along with our two neighboring counties, are unique. There are reasons we may do things a little different. We are small enough that we care deeply about what happens to each and every citizen. Please don't make the mistake of relinquishing the juvenile judgeship. It is one mistake that can never be corrected. I beg you, as commissioners, take the time to give this some deep thought and possibly hold other hearings. The training involved is not that difficult or costly and does not take that much time. People voted for the position of judge to include juvenile judge. If you must change this, do it during an election cycle so that citizens will know that they are voting on relinquishing their juvenile jurisdiction and the position and title of judge. Thank you.
Judge Schaefer.
Good evening, everybody.
Hello. Welcome.
My name is Judge Steve Schaefer. I was the presiding judge up until December 31st, well, or January 7th, or whatever it was that we ended up with some ORS issues. First of all, I live here in Condon, Oregon. I've lived here since 1978. I started my first 6 years of my life living in Condon, moved away, come back. Enjoy Gilliam County. I think it's one of the greatest places in the world. I too agree wholeheartedly with Judge Shaw. Initially, when I come in, I was elected in May of 2012. My thoughts at that time were that, I didn't have the legal background. I didn't have that, and I thought this should be probably passed off. I made a promise at that time to at least give it a year to both Judge Pryor and Judge Shaw. Let's see what happens. As I got into the position and began dealing with some of the issues that were brought in front of me and dealing with some of the attorneys, I want to make a comment about the attorneys. I'm surprised none of them have been able to give input in this, whether it's Matt Ellis or Jennifer Hinman or any of those individuals that I worked very, very closely with that helped guide us into doing what was the number one thing, and I know Judge Stauffer will not disagree with me, and Judge Wolf, Judge Olson, Judge Osry, those people I communicated with, talked with occasionally, the number one thing is the kids. Number one. And I don't believe that it takes a law degree sitting out there to determine whether this is a good thing or a bad thing for kids. If it's something that there was some questions about what was in the law book at the time, we all worked together in trying to create a situation that made it better for the kids and the families that were involved there. The request of that, I'm gonna go back to my training in Reno. One of the things that they asked us to do was stand up and tell us where you're from, what you do, and a little bit about yourself and what your background is in law. I went with Judge Perry from Wheeler County at the time. It come to the two of us sitting there, and there were attorneys. They stood up and they said, "Oh, geez, I've been an attorney for X number of years," or "I've been in handling adult court," things like that. They decided to make the move to juvenile. Why? Because they give them more flexibility in being able to. These were the things that we heard. When Judge Perry stood up, they asked him, well, tell us a little bit. I'm Judge Perry. I'm from Wheeler County. We have a population of about 1,700 people. I do virtually anything and everything that's involved in county government. My background in law is, I watched Matlock. It come to me and it was like, well, I'm a little bit older than that guy. I watched a lot of Perry Mason over the years. There were 42 people that were in that room at the time, from New York, Georgia, Indiana, North Carolina, all over during that period. And we became probably, I would say, the glue in bringing every one of those people together on a regular basis. Why? Because we were small town people. We knew how to communicate with other people. We brought them together. I had dinner with people from Indiana. We went out on the streets of Reno. We gambled. We had cocktails. We did all kinds of things. And it was really, really enjoyable. It brought us together. And these are people that I still deal with. Judges Merkowitz, Boehner, Dodge. Those three individuals sent me condolences when I lost. Now, I got that said. That's out. We have background. We have parenting background. We have skills that we know what is right and what is wrong. When it comes to the legalities of it, there are great attorneys that are going to be in the room, as Judge Shaw said, that will lead us through what is in the best interest of those kids. These are our kids. One of the things that I run into on a consistent basis in either talking with Vicki or talking with Amy, afterwards, we would give an order of what we wanted to have happen. Majority of the time, it had to do with drug and alcohol assessments, psychological assessments. It had to do with requirements on what the kids were going to do in needs of academics. You as a body are responsible for those mental health aspects. You're the ones who make the decisions on what's going to be delivered to the services for our people. We made the decisions on, paying for attorneys, or paying for tutors. Those are important things that you, as the governing body, determined where those expenses are going to be. That's important when you're sitting in that position there, knowing that there is these services setting out there to carry these families to the next step. I can give you stories. Yeah, I can. I wish that more of the people who came in to sit in front of me were here to talk to you. You can understand why they're not here. I mean, this was a difficult time during their life. They don't want to bring it out. They don't want this to be something that they relive. But I can almost assure you that of the cases that I had during this time, I'm convinced they were successful. We carried it to the point to where we handled families. We got the services that they needed. And it was simply because I had two positions here. One, in dealing with some of the finances, knowing that the services that were available, and making sure that there was those services there. That's what's important here, is that we think about, these are our families, these are our kids. They're not, and don't get me wrong, Judge Stoffer, I know you have the same when she deals with the family, or Judge Wolf, or any of them, whether they're from her hometown of Duford or they're from Maupin. But the point is we are small enough that we can do this. We are small enough that we can be a part of this. We can do this. And I think it would be a huge mistake for us to give this up. Again, to answer Mr. Rourke's question about going to the legislature, I'm sorry, but if you make this decision and then you decide later to spend the time and go into the legislature to make the change, that is a poor decision of what your work should be at that time. Going to fight to get this back. Video conferencing, I don't know of any problems. I never had one, and so I don't know where that might have come from. It's worked with perfection, I think, almost every time. Are you aware? I mean, I'm asking you.
The concern was too much video conferencing and not having a judge on the bench.
Okay. Yeah, that
being
is
more.
Yeah. No, I got out of it. And $33,000, I believe that those are budgeted amounts. I'm not sure that that's exactly what has been spent over the past few years.
Budgeted amounts, you're correct.
Which, as anybody who's dealt with public budget knows, that you try and make sure that there's more than enough. Again, I'm going to go back to Judge Pryor, Judge Shaw, myself, and the time that we spent in this job. We're very passionate about keeping this. Very, very passionate. Why? Because we've experienced it. We've been a part of it. We know where our families are. We know who our families are. And if ex parte was an issue, I think ex parte was, might have happened down at the grocery store. Might have happened at the pharmacy. Might have happened at a basketball game. But there's one thing about it, there was just this one thing, and that was making sure that it was in the best interest, everything that we did was in the best interest of the kid and the family involved. All right, thank you.
Judge Warren, I apologize, but I'm going to have to go.
You gotta go take care of your mom. Okay. Well, we are recording it, so you can look back.
I will
Listen.
finish watching, but I do have to go take care of my mother.
Okay. So there was a question that Judge Schaefer raised about the attorneys, and so I just wanted to get on the record because Amy did reach out to them.
I did.
And you can share maybe their feedback for
Mr. Howell, Ms. Hinman, and Mr. Ellis. I believe those are the only three that responded. All did feel that we should move into circuit court. Mr. Ellis had said he would like to see delinquency stay in county court. But the attorneys that had responded to me did all say that they felt with the complexity and the seriousness of the cases, they should be heard in circuit court.
Okay, we'll go on. Larry.
I've got to respond to that because I also had conversations with them a short time ago, maybe 2 months ago, and heard something different. So I want to, they felt that what we did here was just fine. Representation was handled very, very well. And again, the end result was what's in the best interest of the families, or the kids, and the families.
Larry?
Okay, if I stand here,
Yeah, if you want to
very
just,
loud, people probably can't hear me.
if you want to just say for the record though, so that Mary and
Larry Snyder, Condon, Oregon. I agree with Judge Shaw's point, and our lady over here that talked about juvenile director. We are continually losing our local control in every direction. And like they said, none of this was in the election campaign that you were going to do this. I know you had your agenda before the election ever happened, but this is not the way to do it. I was a state police. I dealt with children a lot, not in the family situations, but in minor game violations and traffic. And the personal, and even in town in Tillamook where I worked, you'd see these children in ball games, all sorts of things, fairgrounds. And even though you're an authority figure, they still related to you as a local person. And that meant a lot to them. You cannot lose that local touch. And I think if this wants to be brought up, it should be brought up at the next election, because that way people can know what they're voting on. But they did not vote to have you do this. In the same way they wanted to change our whole county system into a new one. So I think it's a bad move. Thank you.
Thanks, Larry. Kelly.
Kelly Smith, Condon, Oregon. So I have a...
Would you mind actually coming up so that you are in the microphone?
Okay.
Sorry about that. Sandy just told me that I was doing it wrong, so.
So that we can make sure we get everybody recorded.
So that everyone
On the record.
watching at home can hear and.
So I have a youth that has been the delinquent under Judge Schaefer. He heard our case, and I think it went very well. It was a nice personal touch. It was good to have that connection with the judge, to see him around town, you know. It was a good boost for my daughter to get a, you know, hey, I've been thinking about you, I'm glad to see you're doing good, when she's at the grocery store, you know, things like that. And then I also have, same daughter has been the victim in a delinquency case under the jurisdiction of the circuit court recently. So we have been in the courtroom over the
Video conference.
Video conference,
Yeah.
thank you, gosh. And I can say that the video conferencing was very impersonal. It didn't feel as effective, and it was lacking. The second hearing we had in that case, the judge was here in person, and it was good. It didn't feel any different necessarily than having a local judge. She really explained things well. She took things slow. She spoke to both the parent of the delinquent and us as the parents of the victim. And I think we still got a good end result there. So as long as they can be in person as much as possible, I think that's a huge, huge point there. And originally when I heard that you guys were thinking about moving, I was like, no, this is a horrible idea. This is a horrible, horrible idea. And why would we give that control up? The more I think about it, I had not thought about dependency cases at all. And those are serious. The dependency cases are very serious. And I do believe there should be somebody with more knowledge, more legal knowledge, making opinions there, you know. And our youth still have a great support system from local. We have the juvenile director. Amy is a great asset. We have the CASA volunteers. We have, we've got Marion, Marion, the district attorney, is giving his input. There's still a lot of the local. The kids still have the support. The families still have a lot of support. So I think, personally, my opinion would be, like Catherine said, if we can continue signing cases over, feel it out, and make sure it works out in the long run, because the thought of not being able to take it back is scary. That is scary. But I would urge, you know, don't make this decision lightly, because it is, our youth are incredibly important to us. They're our future, and we want them to succeed. And I really wanted to be more prepared, and I'm totally shooting from the hip
No,
here, so I'm
no,
gonna stop
I
rambling
think you did wonderful.
before I start
You did wonderful.
rambling. Thank you.
Judge Shepherd.
Judge Farrar, there is one person here that I think really needs to kind of touch a little bit to really, and the director of the Frontier Casa. You are a person who brings people in that actually represents the family and the kids. Would you be able to say something? I think you bring as much as anything about families and
I put you on the spot, Candy.
He certainly
Do
did,
you
because
wanna-
I don't have my written presentation in front of me.
Do you
like
want to
last
come
time.
up though? Because I need you on. I need you on the mic if I can.
Sorry.
She'll get you back later.
Yeah, she'll be tomorrow.
Yes, I'm sorry, I probably maybe should have requested to, come up and talk at the table again this time. But since I had made the presentation I wanted, the 5 minutes that went into, 25 minutes at Arlington, I still haven't changed my viewpoint on it. I'm not, pushing for it, but I'm still looking at it as what I feel and my board feels is the best interest of the child, and that is with the local, with the court in the local counties. And, we work with 2 counties, and we work with the circuit court judges. We have a lot of the cases now in circuit court, and they're going fine. But I still feel that the neighborhood is still in the best interest of the child. And I also feel that, here again I'll say, is probably one of the most important decisions you're going to make as a judge in a county court, because you're affecting every future court for this county. And so I'll just ask that you really take this very seriously to make that decision, because once it's outsourced, it's not going to come back. So, any questions?
No, I think we
I
talked
have
about
anything.
it.
Yeah, we
Arlington
talked a lot in
meeting, too.
Arlington.
Yeah, we did.
Yeah. Yeah, I don't have any, but thank you for being here and saying something. So.
Okay, thank you.
All right, Judge Morley.
No, I'm good.
You're good? Good. Everybody's covered now? Okay, Reem. Hello.
Reem Durfee, Condon. I came just thinking I had one sentence to say, but then after listening to a lot of this, I've been taking notes and going to say a little bit more, but won't be too much more. I do believe that if this goes to circuit court, that those judges will also care about our kids, and they'll be making the right decisions just the same as our county judge would be. Partly because of what we've heard here tonight, that there's the CASA, there's the juvenile director that has the cases, is in the best interest, everybody's working together, DHS. Those people will still be very involved if a circuit court judge comes to make the decisions. And it's kind of ironic too, yes, I was born and raised here, moved away for a few years, sitting here looking at 3 youth that we all cared about when you were growing up too. And we still do. We care for your kids, we care for, it is a great community, and our kids are our future, and we want them to have the best experience that can be to children growing up. I had 2 children that were in the juvenile system, and Jan Moffett was one time one of their advisors or whatever. She did a great job. I may be looking through rose-colored glasses, but I do think that the system did well by them, and I think that they turned out to be okay citizens. But there again, that was because of everyone working together and recommending the things and following through with what needed to happen. At the time, there was a football coach that kind of degraded one of them, and because of this system, everyone made sure they got counseling, his confidence built, and so, you know, it can only take one or two people that are negative to really have an impact on kids. So anyway, the other thing, I worked for the county in the deputy clerk position for a few years, and I do remember several times the discussion, and there was a few different county judges that I was under at that time. Because of the way things are changing in the world, and everybody seems to be so happy, that's all it's going to take is one lawsuit because somebody feels that somebody wasn't qualified to make the decision, and that would be also a very bad thing for Gilliam County. So just think about that. So thanks for your time.
Yeah, thanks for coming. Darla.
Well, I would like you guys to check with Wasco County why they regret making the decision they did. Could you do that before you decide?
I don't know that Wasco County made the decision.
They turned it over to the circuit court.
No.
Well, which county is it?
Morrow County.
Morrow County?
Is it Morrow County?
Okay, one of them has expressed the regret for that. And I think that's worth looking into.
Angie.
I'm Angie Tennis, I'm the truck administrator here, but I was working in Juvenile and Rural County in that judicial district when that transition occurred. And I don't want to speak for them, but I can tell you there were a lot of additional dynamics at play. I can't tell you that would have changed the outcome or their opinion on their decision. But what I would say cautiously, without speaking on their behalf, is there were a lot of other dynamics that went into that decision and how that decision was made even among their county court at the time. It's my understanding that wasn't a unanimous decision among the county court. So I can understand they may have felt that way regardless of the outcome, but I can tell you there were a lot of other external things that were occurring at the time of that decision. And so I would you could certainly speak to them about more of those details, but there were many other things happening at that time that may have affected their perception of the experience. Not in a defensive way, I don't want to sound that way, I just observed there were some other things that went into that process.
Darla, did you have anything else? That was just a question. Pat, did you want to respond to
The
that?
county I was referring to was Harney County. And I could give you the name of the judge that felt the way he did.
And I don't know much about that process.
But,
I don't know much about their
Yeah.
process, they just happened to be working at judicial.
and I do know about Morrow County and why there were different issues than what we have.
Any more different issues?
Yeah, many.
All right. Marion. Come on up. See us again. You've seen us a couple times on
Well,
this.
thank you, Jan Moffett, for forcing me up here.
Anytime, Marion, anytime.
No, that was powerful, what Judge Shaw said. That took me back. And it's powerful what Judge Schaefer said. And as I came to the other sessions before, and the reason I didn't sign up initially is because I didn't think I really had anything to influence the outcome. My 18 years, I generally appeared before 6 judges over the course of the year, and you don't demonstrate a judicial preference. You appreciate each one, and I feel privileged to have presented to Judge Shaw and Judge Schaefer, and I know how carefully they handled those cases. And I remember one time DHS, after a hearing, said they can't do that because I guess they thought because they didn't have a law degree they couldn't make that ruling. And I said, they're the judge, of course they can. And I was always proud of that. And I also remember, the local influence is always a big deal. I remember one time DHS just wouldn't get involved with a case, and And one of my most important functions every month is to chair a multidisciplinary task force involving children being abused or family violence called MDT. And we knew there was a problem with the family, and DHS wouldn't open a case, so we petitioned the judge to take jurisdiction, and they ordered the DHS to take care of the family. But we could still do that with a circuit court judge. I mean, that's within the power. I will say that in the course of about a year and a half ago, district attorneys, at least in this region, for most of the state, have been distanced from the dependency cases. Until about a year and a half ago, the district attorneys presented for the jurisdiction trials, and we helped put together the petitions to take jurisdiction over children at risk, and we don't do that anymore. That was transferred to the Attorney General's office. So it's distanced me a little bit, and so that made my role on the delinquency side. And that's always been with the district attorneys, it's always been more advisory. I've mentioned at the 2 previous sessions that 95% of the work is done by the juvenile director. She presents the case, she follows the case, she's the probation officer for the case, and I advise her. And if there's a trial, I'll present the trial. But my role is not that much, seriously, compared. It's not like the adult court, adult cases. And so, as I said in the previous one, my position is neutral. I guess on that, I'm like Judge Stauffer. You know, what the county court decides, I'm fine with. But when Judge Shaw came up here and when Jen Moffat talked about her experience, it took me back, and it reminded me of how much pride we took in the outcomes. And I think one of the things that is important from those presentations is we see these juveniles after they leave the system. And we're so happy when they overcome their difficulties and their obstacles, and they're contributing in our community. And we all take pride in them. And whether it goes through circuit court or whether it goes through the county judge, it's the same. And we all feel like maybe we had just a little bit to do with it. And I know the county judges had a little bit to do with it. And so, but as far as whether that would be accomplished in a similar manner with circuit court judges, I just don't have an opinion about it, really. I know we've had good outcomes, but I think Amy did a real good job of describing the process. And everything else is local, except for the decisions of the judge. And for the most part, I'm comfortable with that.
All right. So that's everybody that signed up, but I'm wondering if anybody else's comments maybe triggered something, or there's somebody else who didn't get to speak that would like to speak. No? Okay. Well, this is it for today. At some point, the commissioners will sort of weigh in, I think, on whether this is something they want to pursue, and that this will probably move back within our regular court meetings. But that's sort of the sort of next step of where the conversation happens. So tonight was mostly just to gather input, and I really appreciate folks showing up and on both sides sharing their point of views. I think it was very helpful. Leslie, do you have anything else?
No, I agree. Thank you for coming and sharing. We had another one of these, and there wasn't a very good turnout, so I was really happy to see everybody come tonight.
Fantastic. All right, thanks for coming, everyone. Thank you.